to your calendars. I asked if you have multiple cases, attorneys, that you try to handle them as many as possible before you come to me, and then we'll address them in turn. I'll look at those defaults shortly. Thank you.
Your Honor, as far as Kiana Johnson, with this case with Pharrell, I'm in the hospital, so I'm trying my best from the hospital. I just got it. I did submit a letter saying I was in the hospital. I don't have my ADA accommodation, so I'm not familiar with how this goes. Can you please tell me what's next?
Yeah, so all we would do, ma'am, and I really do pray for your swift recovery, whatever that may be, but ultimately it's virtual, so you would be able to still talk with that attorney in a private breakout room virtually.
Okay, okay. I just need to know. Okay, so you all will do that. I don't know how to
They
initiate
will
that.
they will put you in a breakout room. You'll see an icon, and folks, this is for everyone. You ultimately will see icon that says join breakout room. Do not leave the actual hearing, this Zoom hearing, unless I tell you to, okay? I'm the only one who can dismiss you. But ultimately, you'll be placed in a breakout room, and you may have to wait because one of the attorneys may have multiple cases, and then they will address your case in turn. Ms. Johnson, they may try to get to you sooner because you're in the hospital, but we will see. And then ultimately, you'll have an opportunity to determine if you want to settle the case or if you want to have a trial. Okay. And if we
Okay.
have a trial, we'll have to have that situated. So just be on the lookout, folks, for that icon to join. And then you folks are free to do so.
Sorry, that was my doctor. Sorry.
No, no problem. Thank you for being patient. If you can
Yeah,
raise your right hand, we'll get you out of here. You swear affirm to tell the truth under penalty and perjury of the law.
I swear.
Counsel, give me 1 second. What are those terms?
Judge, this one's a little different, just to be kind of very open and frank with the court. So it's going to be an agreement. Both parties are going to dismiss with prejudice their claims and their counterclaims. Miss Johnson's lease ends on September 30th. She has agreed that if her stuff is not removed by September 30th, those items will be deemed abandoned.
Okay.
And if Mr. Thomas, who is the plaintiff, he and his wife own the property together, that if they find a
Welcome back to the channel, everyone. Buckle up because today we've got one of the most confusing yet hilarious rental disputes ever recorded in a courtroom. Meet Kiana Johnson, a tenant who doesn't want to stay, doesn't want to leave, but somehow has already left. Yeah, try wrapping your head around that. And across the screen, her landlord and his attorney, who look absolutely done with this back and forth nonsense. Now, what makes this case so wild is that Kiana's situation keeps changing. 1 minute she's in the hospital, the next she's negotiating over Zoom about a property she might or might not still live in. This hearing is going to twist between confusion, emotion, and legal precision. The judge is calm, professional, but clearly trying to navigate a storm of contradictions. And just when you think everything's settled, trust me, you'll want to stay until the second hearing, because that's where
thing like that she leaves behind that may be considered valuable, that they will notify me and I will reach out to her and arrange for her to be delivered that.
Okay.
And then with respect to the security deposit, that the parties are going to sign a mutual release, and that when that is presented, they will sign it, and then after it's been signed, which I will prepare and give it to Miss Johnson by hopefully tomorrow, that the security deposit of $1,000 will be paid towards her, available for either pickup at our office, or I will be happy to FedEx it to wherever she wants me to FedEx it to. Does that make sense, Your Honor?
A little bit, but let me see.
Sure.
Draw some blood.
All right, Ms. Johnson, just to confirm, I just want to confirm the terms. The parties are both dismissing their cases, claims against one another, but ultimately you've agreed that you will move out your remaining possessions on or before 9/30/2025, and anything remaining will be deemed abandoned. However, if there is anything that deems valuable, the parties will hold and contact you so that you may retain it or kit it. Moreover, the security deposit will be addressed upon your move out, which you guys will do a move out walkthrough as well. Counsel, is there anything else? No money judgment?
A negative, the security deposit's not quite right, Your Honor. So it's basically,
Oh.
she's going to waive her right to, or we're going to waive our right to the security deposit. We're just going to give her $1,000.
We can see this judge is setting a patient tone. He's calm, accommodating, even wishing Kiana a speedy recovery. But don't let the polite vibes fool you. Judges hear thousands of excuses every year, and a hospital stay doesn't stop the court clock from ticking. Notice how the judge quickly walks her through Zoom procedure and breakout rooms. He's basically saying, "You can't just vanish. I control when this hearing ends." This is subtle, but it's the courtroom equivalent of drawing boundaries early. It's smart, it's firm, and it shows he knows how to handle complex tenant disputes, especially when emotions and confusion are running high.
And she's going to sign a release, and my client will also sign a release.
Okay, so forgive me, Ms. Johnson. So in lieu of that, you will get $1,000 portion of the security deposit, or just $1,000 just in general.
Yes,
from
as
the
a
plaintiff.
judgment. Yeah.
Yeah, and then that will resolve the security deposit issue as well. Anything else that I missed? I'm sorry. You guys got quite a bit.
Is that
Question.
correct, Mr. Farrell? It's not the security deposits, it's just $1,000 judgment, correct?
Right.
Well, it's not a
Yeah.
judgment.
No. No. I didn't say anything about a judgment. We agreed on $1,000 of the security deposit. I don't want any judgment against me or my business or our company. A judgment? Am I clear? A
So
judgment?
what is the clarity, Mr. Farrell?
Yeah, can you clarify?
Okay. Sure. I guess it really is coming from the security deposit, but maybe I shouldn't use that word. There'll be a waiver of the security deposit. My client will pay her $1,000.
Here, the attorney is clarifying something most tenants don't understand. When both sides dismiss with prejudice. That means no do-overs. Once this agreement is signed, neither party can bring these same claims back to court. It's essentially a peace, see treaty. You don't sue me, I don't sue you, we walk away. But there's a catch. She still has to move her things out by the end of the month, or it's considered abandoned. That's legally binding, not just, we'll see what happens. So if she leaves even a lamp behind, it's not hers anymore. And judging by how these cases usually go, that's definitely going to become a problem.
They're not going to be keeping all of it regardless. Out of that, you're going to get $1,000 of the security deposit that you've already paid, and that is upon signing in a mutual release. Again, the parties are dismissing their claims against one another. You'll have to the 30th to remove your remaining possessions. Anything remaining will be deemed abandoned. However, they will keep it, and potentially, if it's valuable, and contact you about it. Furthermore, upon that. Yep, that's what life likes to do to you.
Your Honor, if I may, just for clarification, she used the word judgment, and I'm no lawyer, but we didn't agree on any type of judgment. This is a mutual, amicable agreement.
I got it, Mr. Thomas.
Yeah, no judgment. We had an agreement.
I understand. But I need to wait for her to come back.
Yes, sir, I understand. Just
Ms. Johnson, can you unmute and turn on your camera? Go. Can you unmute for me?
Yeah, I'm sorry about that. I'm getting blood drawn and it just.
I get it. We're gonna make it real quick.
Okay.
You agreed that the terms are that you guys are dismissing your claims against one another, that
Mm-hmm.
you're going to be vacating on or before 9/30/2025, that any possessions remaining will be deemed abandoned, that anything that deems valuable they'll contact you about. And furthermore, you'll do a final walkthrough. Well, ultimately, after you sign an agreement, they will return $1,000 of your security deposit. Are these the terms that you've agreed to?
Yes, the walkthrough of the security deposit would be returned, he said within the next week.
Okay, well, you guys would also be required to sign a mutual release.
Yes.
Okay. Well, then I will get a proposed order from council, which I'll review and sign, and then I will get a copy over to you. And I pray that you do well and you get better, okay?
I appreciate it. Thank you.
All right, you guys are free to go.
Bye.
Thanks, Judge. Appreciate it.
Thank you.
Now here's where the tension spikes. The tenant hears the words judgment and instantly panics. To her, a judgment means a black mark on her record, a potential eviction notice, maybe even damage to her credit. But legally speaking, this isn't a judgment. It's an agreement. The confusion is understandable, though. Most people hear legal jargon and think the worst. What's interesting here is how her landlord's attorney is bending over backward to explain, reassure, and clarify. They're trying to avoid exactly this. But remember, clarity in legal agreements is everything. One wrong word, one misplaced judgment, and suddenly what should be a clean break turns into a disaster.
Yes.
Did you or Mr. Attorney Sinquit have an announcement?
Your Honor, I do. I have a pay and stay agreement on position number 4. And I still have one more tenant to talk to. And I know the court's considering position number 1.
Yeah, and so I just real quick so I can get to deal with Ms. Johnson. Ms. Johnson, raise your right hand. You swear or affirm to tell the truth under penalty and perjury of the law?
I do.
All right, so listen, I've read over your motion. I do see that the original judge had given an order for you to pay in the registry. I do understand that you had certain other conditions and that it was ultimately, that may have altered your ability to do so. And then some other things occurred. Those issues, though, don't necessarily materially address the issue of possession. They're totally fine for counterclaims, but they don't address the issue of possession. Obviously, your condition would really justify you leaving the property, right? So,
May I speak?
sure.
Okay, so as far as the position there, I did go into the property with an ADA need. I had an allergic disorder. That was addressed to the homeowner, and he said that he would make sure that there were no allergens in the home while I was there. A major allergen would be mold. That resulted from an unrepaired and unresolved and refusal to resolve without in a manner appropriately and timely, and that
Objection.
I would before.
So,
Your Honor, we had dismissed the claims and the counterclaims. I think we're in front of the court on a motion to enforce what she contended is an oral agreement. It has nothing to do with everything that happened before.
Your Honor, I'm not.
Well, hold on. I see an order. I see an order for continuance. I see a motion to compel rent, an order regarding such. I don't see a consent order, but I do see the motion to compel rent into the registry, which is the basis, I believe, why the writ was requested, because the $1,300 was not paid in the registry. Is that correct?
Your Honor,
Your Honor.
You said no?
No, Judge, you signed an order that should be part of the record, which I can, share with the screen.
Hold on. If it's been, I'm sorry, I saw them. It seems like there's been 2 judges. I see Block's been on here as well. So hold on.
Mm-hmm.
I see this oral agreement, but counsel, you're saying there's a different agreement? I mean, this alleged oral agreement where she's.
Judge, you signed an order. It should be in the docket. I can share the screen.
I think I had the position first. He objected. Can I go back to my position?
Just hold on. I want to see what I'm looking at first. Okay, so there's a consent agreement. That's important. And so the consent agreement indicates.
Let's pause for a second. What would you do here? You've already moved out. You're getting $1,000, and you get to walk away with no record, no eviction, no future headache. Sounds like a win, right? Yet notice how hesitant Kiana still is. She's juggling hospital stress, legal terms, and uncertainty about her belongings. This moment captures something so common in court. Emotion versus logic. The judge is trying to finalize a clean resolution, but emotionally, the tenant isn't ready to let go.
Parties have agreed that defendant Keena Johnson and all others will vacate the property located at 2179 Diller Crossing, Tucker, Georgia, on or before September 30th at 5 p.m., and that anything left behind shall be deemed abandoned and may be removed without further order of court. Plaintiff sees anything valuable. Yeah, I feel like I remember this case. Further ordered and the judge, plaintiff's complaint, defendant's counterclaim. Yeah, so I understand. What's going on? Today's the 30th, Ms. Johnson. You found a consent agreement. I'm not trying to be difficult with you, but there's generally no appeals, of the consent and modification of such.
Your Honor, I'm respectfully asking under my conditions for a chance to speak.
Sure.
And I'm gonna speak by narrative, if you don't mind.
Well, I would ask that you just be respectful of the time and
Yes,
address specifically. So hold on. Let me ask this. Why do you believe that the consent order which you signed, saying that you would vacate by the 30th and dismiss all your counterclaims, should that essentially be not considered in lieu of your signature on such, or in lieu of the agreement that I find that you've entered into?
Your Honor, the reason being, and before I go into that, I will say that I did ask for ADA accommodation.
At this point, you can feel the judge's patience being tested, but he stays composed. Notice how he repeats the terms again and again. This is courtroom strategy. When a party keeps misunderstanding, judges often summarize repeatedly to make sure it's on the record. That way, if the tenant later says, "I didn't agree to that,"